I now have a question for Kenya and for Leon. So you will be asked to answer a long question on the closing of the road we talked about previously. So here is your question. Does the closing of the main coastal road from Al-Kawa to Aden violate international humanitarian law? And could there be situations when it would be lawful to close the road completely without violating international humanitarian law?
Thank you very much for the question. For the purposes of organizations, I've divided my answer into 3 parts. First, I'll qualify the conflict, then I'll address the facts, then I'll apply the law to the facts. To qualify the conflict, we must understand that this is a conflict between the Yemeni government forces and Ansar al-Sharia. Therefore, it is non-international in nature, and the applicable laws are Additional Protocol 2 and Common Article 3. From the facts of the case, we can see that Ansar al-Sharia's nature of activities is that they had occupied other areas, but were currently only occupying Al-Qad. And therefore, the closure of this road is necessary for security reasons, and it can be justified on that basis. However, because of the humanitarian purpose of this road, being that it connected, it was the quickest way that civilians in Al-Qad could access the better medical facilities in Aden, it is necessary for them to also put that into consideration. And it's also, it's in light of this that IHL does provide for the provision of not only medical care, but medical care to the least possible delay and to the fullest extent practicable. And in this situation, the closure of the road does not violate IHL, as long as it's not the complete closure. And the security checks that are in place are expedient. For example, I'm thinking of a practical situation where the security checks are there, but they are expedient, and even in situations where there's, let's say, a long line of people waiting to go through the security checks, that the people who are wounded and sick should be put to the front of the line and therefore be able to access their medical attention to the least possible delay. And this will also take into account the practical situation on the ground, which is also provided for under the laws of IHL. And therefore, it is because of this that also its complete closure would be in violation of IHL, but its closure is not in violation of IHL, because its complete closure would make it so that the civilians cannot access their medical care, which from the facts of the case we can see is better provided for in Aden. Thank you.
Okay, thank you, Leon, for your answer. I think on this particular issue we would like to have Ken's opinion, so on the closing of the main coastal road. So Ken, from a military perspective, how in practice do you balance security and humanitarian considerations when deciding on the closing of a road, and how do you manage concretely to ensure this balance?
Hi, Djemila. Thank you very much, and good morning from Haiti. You're absolutely right. I mean, the question is about balancing humanitarian obligations for the military, humanitarian needs, and setting those against military necessity. And I was very interested in the comprehensive answer provided by Nairobi, where I think it really turns around what you mean by complete closure. As I think you mentioned in the intro, I spent some 20 years commanding soldiers on military operations, and in my considered view, there are occasions, particularly in a non-international armed conflict, where it will be necessary to deny a route for a specific period, primarily because your opposition is able to fade into the civilian population, and thus if you don't deny a route, you allow civilian passage down that route, you may well be allowing the opposition to escape from a particular operation that you've set for him. So I think, in my view, specific short duration closures, if it is militarily necessary, can certainly be considered. However, the commanders concerned must assess the humanitarian consequences and their obligations under IHL. What they can't do with a road closure is to deny access to goods essential to the survival of the civilian population for an extended period. And if we're talking about 24 hours, clearly that may not necessarily be relevant. Much more relevant, of course, though, is the obligation to allow treatment for the wounded, and indeed the obligation applying to the military themselves. And that is relevant even in a short-term road closure. So therefore, if you're considering closing a road as a military commander, the first thing you must do is assess the consequences and what your obligations are. If it's feasible, you must coordinate with humanitarian actors in making that assessment. If you're then going to close the road totally, you must still allow medical passage. And again, you can coordinate that with the humanitarian agencies. Either there can be a certain window for that to take place, or it's done directly on a case-by-case basis. But of course, you still have the right to search medical vehicles, medical evacuation using that route. If, however, you consider you must close that route completely, then you have an obligation to provide an alternate route for medical evacuation, and again, that can be coordinated with humanitarian actors concerned and must be made known clearly to the civilian population. You might, in extenuating circumstances, also consider use of military assets to provide medical evacuation capacity. And all of this needs to be set out in very clear standard operating procedures for the military. Orders to soldiers need to be very clear, prioritizing medical needs, and there needs to be commanders in situ to make sure that is properly executed. Thank you very much.
Thank you, Ken, for your answer. I would like briefly to come back to Alexander, because we've just received an interesting question from our online audience. So someone is asking you if the does the armed group, if present, does the armed group represent need to make sure that there are no appearance of military activity in addition to not having such activity? So it's in relation with the question of emblem and perfidy. Would you like to add something on this particular issue, Alexander?
Yes, thank you, Djemila, and thank you for the interesting question. I mean, first of all, what we need to be aware of is that this concept of hostile acts outside the humanitarian functions is actually a bit broader than merely, launching military operations as to, constitute attacks. But this I mentioned earlier, and this sort of ties in with your question. With not letting the medical facilities appear to have a military activity conducted inside. This refers to any acts whose purpose or effect is to involve the medical facility in military operations, and this can be already be the case when merely, arms and ammunition, for instance, are stored inside a hospital without them being actually effectively used from the hospital, or simply for using the hospital for, liaising with fighting members of the armed group. And we should also not, of course, forget that a medical facility at all times has to be exclusively used for medical purposes. And thus, if there is any military activity conducted from inside, this increases the risk even for those that are innocent of such hostile acts, that the hospital as such, and this we will come to later on, might be at risk of an attack. So to that extent, no military activities whatsoever should be conducted. That said, as we will see also later on, there are certain functions that are permitted inside hospitals that might create a military appearance as well. So it is not excluded, for instance, that medical personnel may be equipped with light individual weapons for defending themselves or for defending the wounded and sick. So this is, these are scenarios that are expressly provided for also under ICRC, that are expressly singled out as to not constitute such hostile acts, and that would not have the consequence that the whole medical facility afterwards would lose its protection.